And I'll give the floor to His Excellency, the Permanent Representative of Sri Lanka.
Thank you, Madam Chair. As much as I would commend the bold spirits that put down draft Articles 13, 14, 15 in black and white, I would venture to strike a note of caution when we endeavor to address the rights, obligations, and procedures applicable to the extradition of persons for alleged offences in terms of the draft articles in its present form. We know that in the ordinary course, the process of extradition is whereby the requesting state would ask the requested state to send back the suspect to the requesting state to enable the offender to stand trial in the requesting state. It can also be that the request can be made for extradition of a fugitive from justice, inclusive of a convict who has escaped. Many of our countries have bilateral treaties on extradition, although that is not strictly necessary. We know that Resolution 3074 of the United Nations highlighted the need for extradition of persons who have allegedly committed crimes against humanity to make sure that they are prosecuted, proven guilty, and punished. You will note that the Subcommission on the Promotion and Protection of Human Rights of the Commission of the Human Rights reaffirmed that principle. I am respectfully of the view that the mere satisfaction of the principle of aut dedere aut judicare in terms of Article 10 is not to be taken lightly. The threshold criteria of a reasonable suspicion, as my Russian friend was pleased to observe this morning, of sufficient evidence must be satisfied to trigger the jurisdiction. It cannot be a fancy suspicion. It cannot be an arbitrary suspicion. It cannot be a suspicion structured on political grounds for political purposes. It cannot be a suspicion at the whims and fancies of the powerful. That would be clearly anathema to the rule of law, Madam Chairman. We must bear in mind that the liberty of any human being is sacrosanct. It cannot be used as a tool of the powerful to move human beings like pawns on the chessboard of global politics. And we have seen this happen, and we cannot afford to countenance such conduct for the present or for the future. We are of the considered view that Article 13 must be given more than careful consideration. We must bear in mind there is also the aspect of public policy that comes into play. I am fairly sure, Madam Chair, that no state would hand over an offender to another state, more particularly a national of that state, when the circumstances are such that the person sought to be extradited will not be ensured a fair trial in the territory of the requesting state, and we have living examples of the situation if we look around us. I believe that Article 13.3 seeks to anticipate precisely the concerns that I expressed a few minutes ago. I must more respectfully beg to differ with the last sentence of Sub-Article 3, which leaves the window slightly open by using the words, quote, extradition based on such an offense may not be refused on these grounds alone, close quote. I believe that extradition must be refused on any one of those grounds for the reason that handing over a judicial process to a political process would be anathema to the rule of law. Now, Sub-Article 4 appears to be equally ambitious as it seeks to put in place a universal treaty that permits extradition. I'm not so confident that many states would have the appetite to digest such a wide-sweeping legislative change to accommodate this process. I'm also of the view that these laws need to be tested for consistency with the constitutions of our countries by way of perhaps by judicial review. Now, Sub-Article 5 appears to provide an escape clause for those who leave the questions of whether to adopt or not as a matter of simple choice, with a fallback situation of the safety net of informing the Secretary General or to enter into ad hoc treaties with contracting states at their pleasure. Now, Sub-Article 8 creates a space for expeditious disposal of the procedure, and I hope I'm wrong, to lower the threshold of evidence. Mr. Chairman, I wish to remind this Assembly that we cannot sacrifice justice on the altar of expediency or condemn the worst of them by a consideration of evidence in a simplified form. I'm of the respectful view that there is only one type of evidence that can be presented in a competent court, and that is evidence so that we can be sure, at least on a preponderance of material, that the procedure must be invoked. We must remember that if we do not defend the worst of them, that we cannot defend the best of them. Sub-Article 10, for all intents and purposes, would not be easy to find accommodation in our courts. I cannot see any court proceeding to incarcerate a person on the basis of a conviction in a foreign court unless it is sure that the conviction that has been secured in terms of the procedures established by law. This may be a fit and proper matter, perhaps, for extradition. Draft Article 14, which deals with mutual legal assistance, in my view, is a sweeping provision. These provisions had to be brought in line with our own statutes governing mutual legal assistance in investigations, prosecutions, covered by the present draft. It is my respectful view, as referred to in the annex, mutual legal assistance by the requested state must be made to the designated central authority of the requested state. I must, however, concede that the underlying principle that has been laid out in draft Article 14 is an aspect that is worthy of favorable consideration, subject to the reconciliation of the condition set out therein with our own legislative instruments. To say a word of draft Article 15, it is my view that we must sufficiently join issue on matters between states themselves. The mutual respect for the concept of sovereignty as enshrined with the UN Charter must be respected. If states cannot agree on a particular issue regarding mutual assistance, it must be allowed to rest where it falls. We are disinclined to accept the position that we should go so far as to invite states disagreeing on a matter concerning the interpretation of the present draft articles to be submitted to the International Court of Justice, which might be a luxury for most of us who only require a simple, clear, predictable legal system that facilitates the promotion of a dignified lifestyle for all our citizens. Madam Chair, let me conclude by what Professor Jerry Simpson, in his article, International Criminal Law, The Next 100 Years, said, quote, in the world of rogue hyperfinance, ecological self-destruction, trigger-happy nuclearism, dark webs, black money, half-crazed populism is in international criminal law. Really, where is international criminal law then? Then there is an atmosphere of decay, backlash, recession internal to the field, the withdrawals and threatened withdrawals from the ICC, the sunset of ad hoc tribunals, the sense of a late-style torpor settling over ICL institutions. Of course, new proposals continue to be advanced, such as the crimes against humanity, again, as in this draft. But international criminal tribunals do not feel like the future. And when the history of the future is written, he says, ICL itself might have a vaguely asterisk quality. So at the very moment of its consummation, or completeness and normalization, it is experiencing, he says, a moment of anticlimax, or it's becoming what the editors, he says, call, in a more mellifluous term, a tenuous proposition in a deeply divided and lateral international environment. Thank you, Madam Chair.
I thank His Excellency, the Permanent Representative of Sri Lanka, for their statement